we're good.
Okay, well, welcome to our first Ask an Expert. We've got Jim Hasson joining us. Thank you, Jim, for taking the time. I know everybody on the line. This is Bill Hoffman speaking for those who are listening to this later. Jim's going to be talking about legal guidance and what it takes to change scholarship restrictions for donor-advised funds, endowments, and other situations. And Daisy, I wonder if we could start and just introduce everybody, who they are, where they are, who they work for, so Jim has a little perspective.
Hi, good afternoon. I'm Daisy Franklin, Central Florida Foundation. I'm the community investment manager, so I work with all of our scholarships, grants, initiatives, giving circles related to the grant making.
Gila?
Hey, Jim. I'm Gila Ferguson. I am the program director for the Florida Philanthropic Network. So just want to thank you for being with us today and sharing your insights.
And Bob.
Yeah, good afternoon, Jim and everyone. Bob McFalls, President and CEO of FPN. Really glad to be able to launch this series and appreciate, Jim, your being with us and sharing your expertise.
Sure thing.
And this is a very informal format, but I'm going to hand it over to you, Jim, and let you take it away.
Great. Thanks very much. I appreciate the opportunity to talk with everybody, and hopefully we'll have a chance for some questions here in a few minutes. I thought that we would begin by just going over some of the basic ideas that occurred to me regarding the restrictions on scholarship funds and which of those restrictions might be troublesome or perhaps even illegal at this particular point. And if you have problems, how do we go about making changes, and what are the procedures that are possible? I'll have to put in the typical legal disclaimer that you'll hear from any lawyer doing this sort of thing, and that this isn't legal advice for any specific situation, but it's general educational background. Most of what I'm going to be talking about has to do with federal law and with uniform state laws as applicable in Florida. I've put together my own sort of scribbled notes that are in an outline format that I would be happy to clean up and send out to folks if they would find that to be useful. So Bill, either you or Bob might receive requests from folks that would want a copy of the outline, and if it has any sort of broader interest, we might figure out some way of getting it posted on FPN. But the basic question, of course, is whether changes need to be made in any scholarship restrictions that now exist at either a private foundation, a community foundation, a donor-advised fund, a private school, or any other situations in which a scholarship fund might be established. The probable answer for most folks in FPN is that there's not going to be a change, that there's not a legal barrier to the utilization of restrictions on scholarships. But it's possible that there are some restrictions that are troublesome, and if so, we want to figure out what we need to do about them. Now, at the moment, there are not great changes taking place in terms of scholarship restrictions. Most of the dramatic changes occurred 50 years or so ago. There is some current activity with respect to gender and race-based scholarships that are of concern and that we have to pay close attention to. But most of the changes that were necessary in scholarship funds came about 50, 40 years ago. We, of course, had the 1964 Civil Rights Act. We then had the 1969 Tax Reform Act that imposed restrictions on how private foundation scholarship programs could operate. We then had a decision by the Internal Revenue Service in 1970 concluding that private schools could not have a racially discriminatory admissions policy if they wanted to retain their tax-exempt status. That was formalized in 1971 and again in 1975. It was approved by a United States Supreme Court decision involving Bob Jones University. That was in 1986. We had gender discrimination become illegal in 1972 in educational programs that accepted any federal financial support. In 2006, we got the Pension Protection Act, which imposed restrictions on donor-advised funds of community foundations and other sponsors, basically saying that donor-advised funds could not provide scholarships unless a specific type of scholarship committee appointed by the sponsor was in charge and unless the private foundation restrictions on scholarships were followed. There have been very few other judicial decisions of direct relevance to scholarship programs. The most notable one was in 1994, a decision from the Court of Appeals for the Fourth Circuit in a decision referred to as Podbersky versus Kerwin. Here, an Hispanic student brought a claim against the University of Maryland that a scholarship fund administered by the university for the benefit of only for the benefit of African Americans was unconstitutional. He won that case. The Fourth Circuit Court of Appeals said that you could not provide scholarships exclusively for African Americans unless some very narrow remedial actions were being targeted. Those were not sufficiently targeted by the University of Maryland. And so that was, that scholarship program was eliminated. Now, if we have a problem in Florida, there is a ready statutory provision that's available to make changes in restrictions that may exist with respect to scholarship programs. Florida, like most other states, has recently adopted what's called the Uniform Prudent Management of Institutional Funds Act, which goes by the acronym UPMIFA. This was an update and an expansion of an earlier law called UMIFA. The new law in Florida, which was adopted in 2012, expands considerably the scope of organizations to which it applies. And to the surprise of many people, it deals with more than just investment activity. It also addresses changes in the purpose or the restrictions that are imposed upon specific funds, and that would include scholarship funds. The way that Florida approached this particular statute was it distinguished first between situations where the donor was still alive and where the donor was willing to consent to a change. If the donor is alive, capable of making a change, and consents, then that is all that is necessary to change or eliminate a restriction. If the donor is not available, not alive, can't be found, what have you, then the Florida statute constructs a 3-tier system that depends upon the size of the scholarship fund. The lowest tier is for any fund up to $100,000. Second tier is for funds that have a value between $100,000 and $250,000. And then the third tier is for funds that have a current value over $250,000. If you're in the lowest tier, the institution itself can make a change if a restriction is impractical or impossible to perform. Unfortunately, the Florida statute does not use the word unlawful for this lowest tier, but we'll come back to that in a moment. The second tier for $150,000 to $250,000 funds can be initiated by the institution that holds the funds. Notice has to be provided to the Florida Attorney General. The Florida Attorney General can intervene. If the Florida Attorney General does not intervene, the institution itself can go ahead and make the change if the restriction is unlawful. Then the highest tier, funds that are over $250,000 in value, can only be changed by a court, and also requires notice to it and an opportunity for intervention by the Florida Attorney General. Now, there's one odd thing about that middle tier. That middle tier, $100,000 to $250,000 fund, literally applies only if the fund has been in existence for 20 years or more. That does not apply to the other tiers. It's an odd provision. Fortunately, the Florida statute contains a catch-all provision that would say that any restriction can be changed by a court at the request of the institution holding the funds, and if the Florida Attorney General is given notice and an opportunity to object. Now, there are some trusts, charitable trusts principally, that MIFA does not apply to, but fortunately Florida has a statute that permits courts also to change the terms of charitable trusts if those are unlawful or impractical. So now we come to the basic question: what would make a scholarship fund restriction or limitation unlawful? The conventional analysis, the analysis that exists up to this point in time, basically differentiates between totally private institutions and institutions that receive any federal or state governmental support. Most colleges and universities now receive federal financial support. Most private schools and charter schools receive state financial support or federal financial support. And so most schools, even though they are private nonprofit organizations, receive federal funding and therefore are subject to the federal restrictions, statutory restrictions, and constitutional restrictions. The basic rule for organizations that receive governmental restrictions is that they cannot have restrictions on educational programs that are limited by race, national origin, color, and that if there are restrictions that are based on gender, age, disability, there has to be some demonstration, some factually based demonstration that those restrictions are necessary in order to carry out a legitimate governmental purpose. So where that leaves us is that most schools, and therefore most scholarship programs, are going to be subject to some degree of limitation or restriction. I would expect that private foundation funds, private foundation scholarship funds in Florida, and donor advised funds in Florida are not likely going to be illegal or restricted by federal or state law unless the restriction is based on race and is a restriction that discriminates against a minority or a disadvantaged racial category. So that seems to be the current state of the law. We know about at least two significant current challenges. We've talked about in a prior session, and others of you are undoubtedly aware of the litigation that just concluded, the trial that just concluded in Boston in federal district court against Harvard University, challenging its admission standards with respect to Asian American students. The facts seem to bear out pretty readily that Harvard imposed more rigorous admission standards on Asian American applicants than other applicants. It did so, or its defense in this litigation was a diversity defense. It needed to impose those types of restrictions to limit the number of Asian American students and therefore to promote greater racial and ethnic diversity among its student body. The comments by the court at the conclusion of the trial said that both parties had weaknesses in their case. The weaknesses on the part of the Asian American students was that they intentionally chose not to present individual Asian American students as witnesses for fear, assertedly, of their being discriminated against, harassed, mistreated in some fashion. The weakness on the part of the university that the court identified was its admitted use of restrictions to limit the number of students from a particular racial or ethnic category. Since the court said both sides had weaknesses, we may see that that case gets settled out of court rather than going to a decision. That would be the normal result when a judge makes those sorts of comments. So we'll just have to wait and see what the coming months hold on the Harvard litigation. Another recent action involves Tulane University, private university in Louisiana, in New Orleans. It took over the operations of a women's college. It retained the endowment of the women's college and uses it for scholarships for women only. A complaint was made to the Office of Civil Rights of the U.S. Education Department. The U.S. Education Department initiated an investigation of Tulane. Tulane has settled the matter, at least temporarily, by saying it would re-examine all of its gender-restricted scholarships and would eliminate those that are illegal or problematic. It suggested that it would do so by using its own unrestricted funds to establish scholarships for men that would be equal in amount to the scholarships that were available only for women. Now, if that solution were the required solution for private foundations or for donor-advised funds, it would create havoc. It would create administrative chaos and considerable difficulty, I would suggest. And so because foundations, donor-advised funds would be put in the situation of trying to figure out, well, how are we supposed to go about some sort of balancing of gender-restricted funds for women with gender-restricted funds for men, racially restricted funds for Hispanics with racially restricted funds for non-Hispanics, and on and on and on. So that's a troublesome development. Again, we don't know what the result is going to be, but it's something that we're going to have to pay pretty close attention to in the coming months and perhaps years. So those were my overview comments. I hope that was of some value. I obviously welcome any kind of comments, questions, responses about your own situations that would be of some help to the group.
Thanks, Jim. Daisy, any questions?
Not at this time. I took a lot of notes. But I don't think anything at this time impacts our work.
Sounds like you ought to sleep comfortably tonight then. Anything else that anybody has?
Bill, we can't hear you. I think you might
I was muted, sorry. I was saying, Jim, I took a lot of notes too. Do you have any idea when the Harvard litigation is likely to be finalized?
In a case like this, assuming there's not a settlement, if it goes to a decision, Bill, I would not expect a decision until the very beginning of summer or perhaps into the fall. There was a massive amount of statistical evidence presented to the court, and the court's going to have to work. It's a female judge. She's going to have to work her way through that pretty carefully, I think, to try to determine if there's enough evidence to make a decision. If that decision, regardless of how that decision comes down from the district court in Boston, there almost surely will be an appeal to the Court of Appeals. And I would expect that depending upon what the Court of Appeals says, there could well be an appeal to the Supreme Court or an attempt to obtain a hearing before the Supreme Court. So if it remains a fully litigated case, we could easily be 2 to 3 years away from a resolution.
And the other question may be more of a comment. When you were talking about the 3 tiers for making changes to scholarships, it sounds like unless a foundation has experience with that process, they probably need to seek legal advice at least the first time through that. And it also, to me, sounds like it's not something that's going to happen that frequently.
I don't think it will happen very frequently. I think you're correct. Hopefully, there are not many troublesome scholarship funds out there that are held by foundations or donor advised funds. The process is one that's fairly technical, and certainly where you have to provide adequate notice to the Florida Attorney General. You want to do that with some care, because nobody wants to invite an investigation that they don't need. So it should be done carefully.
Sounds prudent. Well, great. Thanks. We're at 2:30 right now, just turned at 2:30, so it's a good time to stop. Thanks again, Jim.
Thank you very much.
And we will be posting a recording of this. Have a great rest of the day.
And if you think it would be useful to get notes out to folks, just let me know.
That would be helpful.
Appreciate it.
Great. Thanks very much.
Thanks, everybody.
Thanks all.
Bye.
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 Bye-bye.